Hi, I'm Elizabeth Payne-Maddalena, a senior associate attorney here at Berenzweig, and I'm joined today by my colleague.
Hi, I'm Aleksey. I'm an associate here at Berenzweig, and I'm here today to talk to you about California's new Data Privacy Rights Act with Liz.
That's right. The California Privacy Rights Act goes into effect on January 1st, 2023. But when it does, it's going to have widespread effect on many employers, even outside of California, if they have California employees, independent contractors, or job applicants. It's my understanding that this law is going to significantly expand some data protections. Is that right?
Oh yeah, it's significantly impacting the legal landscape as a whole, and there are expanded data privacy rights involved under the CPRA, and it's something that employers need to be aware of. But it's not going to apply to all employers. There's some threshold requirements that will determine which employers it does apply to and which don't. But it certainly is something to be aware of. But no need to panic just yet, because the key is to just start preparing and organizing now, and we'll figure out if it applies to you.
Exactly. And those requirements, those threshold requirements that you mentioned, are very important, because that's where the cookie kind of crumbles when it comes to who's going to be covered by this and who isn't. So we've already mentioned, if you're an employer and you have a California employee, independent contractor, or job applicants out of California, including for remote work positions, this law may apply. Now, what it comes down to is whether or not you're either an employer, a business that is selling or sharing large amounts of consumer information. 50,000 consumers, or 50% of your business is based on these sales, is generally the threshold for that. Or if you are any kind of company that has a annual gross revenue of more than 25 million. And that's where a lot of employers are going to suddenly get caught up on this, because again, it just takes one California employee or independent contractor for this law to apply for at least those employees.
And I think that's an important point to emphasize, because when people think data privacy, they think, I'm not in tech, or I don't sell consumer information, so this isn't going to apply to me. But I don't think that's the case here, right?
No, not at all. This applies to any kind of company with any focus or in any industry, as long as you have that California employee, applicant, or independent contractor, and your annual gross revenue exceeds 25 million.
I mean, that's a significant expansion from even the CCPA. That's a revolutionary law in this field.
Right, and that would be the California Consumer Protection Act, and that had to do with just consumer-based data. But I think one of the most important things to talk about, first of all, is what does this law actually do for California employees?
So like I mentioned, it gives them, expanded rights. The right to know what information is being collected, how it's being accessed, what the employers are doing with it, how it's being stored, and there's other rights too. The right to correct, the right to opt out of certain collections, and because of these additional and expanded rights, it creates additional obligations on those employers.
Right, including a non-retaliation right, and there can be some penalties involved for employers who do violate this. But I think the most important thing for employers to start thinking about is what actions they're going to have to take to comply with the CPRA if they're covered. And the two biggest aspects of the CPRA are going to be the notice and privacy policy requirements. And these are notices and policies that employers are going to have to start giving their employees or independent contractors or job applicants in California when certain kinds of information or personal information is being collected by the employer, and certain requirements need to be included in these notices and these policies explaining what the employer is getting this information for, what it's being used for, what steps the employees can take to review that information or delete or change, etc. All of that would be laid out in these documents. And there's also some other requirements in there about creating processes for reviewing these kinds of employee requests. It sounds like a lot, doesn't it?
I mean, every time you go on a website now, you get hit with that, privacy policy. Do you accept this? Do you opt out of this? Like, this is how we use your information. And it kind of seems like that's going to be translated, to the employment context now. Like I'm assuming that it's when you apply for the job they have to give you this notice.
Yeah, so it will apply in all sorts of contexts for the employment. When, for example, as Aleksey said, if you have someone in California applying for a position, that's going to apply. It's also going to apply for various aspects of perhaps you're having employees update benefit information. You'll want to make sure that you give them a notice of collection there. It's also going to apply to some of your service agreements with your service providers. Think health insurance, think even your ISPs, your internet service providers. You may need to update some of your service agreements with them. But I think the first step is employers have to figure out what exactly they're collecting, right?
Exactly. So, you have to develop that compliance program. But before you can even do that, you have to, engage in some data mapping. You have to find out, what employees are we collecting this information from? Where are they located? How are we storing it? Like, what kind of protections does this information need? And, that's the main goal with this data mapping. And it's going to, create and give you the outline and the structure of what your compliance program is going to look like. Is it going to be, well, that's a question actually. Is it going to be California only? Is it a uniform approach, or is it going to be state by state? What do you foresee employers doing down this road?
Well, and I think that's a very good question, because in the end, I think for many employers, it's just going to be logistically and cost-wise too much of a headache to create separate data protection policies and procedures and processes for California employees and then other state employees. So I think most employers are probably going to end up doing a one-size-fits-all approach, and if they're covered by the CPRA, it will probably end up just applying it to all of their employees. But I think that might actually help employers in the long run.
I agree 100% because, California is just the first one. In 2023, California, Colorado, and Virginia are all implementing, similar laws, and those are just the first three. There's also discussions at the federal level, and, who knows what's going to happen with that. But at this point, I don't think it's an if these data privacy laws are going to be enacted, because it's a trend that's around to stay. And I think at this point, it's best for employers to, continually be proactive to, get ahead of this. So if the CPRA is coming out now, you should probably start looking at your policies and the way that you handle sensitive information, because, like I said, it's around to stay. And to better adapt in the future and mitigate risk and, reduce exposure, you should probably start, preparing for this trend, because data privacy is something that's here to stay.
And I think I completely agree, Aleksey, and I think this has been a great discussion. I know we'll be staying on top of the CPRA and all of the developments as more and more comes out of California on how exactly certain parts are going to work. We'll also be watching Virginia, Colorado, possible federal legislation. And if anyone, of course, has any questions about the CPRA or thinks it might affect them, please feel free to reach out to us. Aleksey and I are happy to help out with developing that compliance process and just advising businesses as to whether or not this is going to affect them and what they need to do to prepare.
Yeah, and like Liz mentioned, we'll continue to monitor any developments and as these laws continue to evolve, but we're here if you need us.